picked early, and so the nuts were just not of the quality that they were expecting for their almonds. Now, when they did turn to groundwater, you know, groundwater's been in the public lately quite a bit, and our groundwater pumping has exceeded the safe field of our basin over the last 3 years. Last year in 2013, we pumped about 640,000 acre feet. This year, we're on pace to pump between 675 and 700,000 acre feet just within Westland's service area. Those are levels that have not been seen since before the CVP was constructed. We have not pumped that much groundwater. We have not reached our historical lows before the CVP was constructed, but a couple more years of this, we're probably going to get to that point. So we're experiencing a level of overdraft that is not sustainable for our groundwater basin. And I heard the comment earlier, and a lot of our farmers are also worried that their farms are not going to be around in 10, 20 years for their children. And that's a big concern that I hear from our farmers every week. Related to the groundwater, many of our farmers that actually had wells experienced drops in well yield. They paid higher costs, higher energy costs to pump that groundwater, and sometimes they actually experienced well failure, and their wells just stopped operating. So they had to make a choice whether to abandon those fields that were relying on the groundwater or shift their irrigation practice to keep some fields going and fallow others, or not harvest and just abandon some of their fields before harvest was complete. So tied to land fallowing, we actually just finished our crop report. Westland's fallowed about 220,000 acres this year. That represents about a third of our district area. So 220,000 acres of productive ag land was taken out of production. And again, for scale, 220,000 acres represents about 7 times the cities of San Francisco. And that probably stretches from the Golden Gate Bridge down to Redwood City of land that was fallowed. And that relates directly to jobs that impact our communities. Farm workers, packing shed workers, cold storage workers, and any of the ag-related businesses. You have communities in Huron, Mendota, Coalinga. They're all suffering because they depend on the jobs that are created by the farm industry within our community. And these are some of the most marginalized and socially and economically disadvantaged communities within California. And without the jobs, they just don't have the work or the opportunity to succeed. All right, thank you.
Thank you. Mr. Rubin?
Good afternoon, Madam Chair, members of the board. My name is John Rubin. I'm General Counsel for the San Luis and Delta Mendota Water Authority. And I'm going to be responding to the third question that you posed for this workshop, and specifically the question that asked whether the draft order that has been released is sufficient. I believe a basis for asking the question is because the State Board wants to have better information during times of shortages to administer the state's water rights system consistent with water right priorities. If that is the basis for asking the question, the Water Authority does not believe the draft order is sufficient. The focus on riparian and pre-14 water right holders, those that claim water rights, pre-14 and riparian water rights, should be on the South and Central Delta. That is appropriate. However, the State Water Board needs more information than requested in that order. The draft order, as I read it, is focused on water use and water availability. But the information that the State Board needs, the foundational information that the State Board needs, is information to support the claimed rights. And I'll walk through at least, I'll walk through 3 reasons why that information is necessary, but I'm sure there are others. First, and maybe most obvious, is that the Delta is unique. It is the confluence of critical environmental, water use, water quality issues and regulations. Second, most of the in-Delta claimed riparian and pre-14 rights have never been verified. And as I've cited previously, there's a 1956 cooperative study report that was done by Department of Water Resources, the Bureau of Reclamation, and Delta interests that make this point very clear, particularly with regard to those claimed riparian rights. And third, many of the in-Delta water users assert a common date of first use, assert multiple claims, and as a result, assert that they are able to divert water, the full quantity of water that they believe is necessary to support the uses. I would note that the focus on the Delta is a point that has been recognized by this board, the State Water Board, in its strategic plan for the Bay Delta. There's also a point that's been noted by the California legislature in Senate Bill 8, Section 1, which was enacted during the 2009 special session. And for all of those reasons, a focus on the Delta is important. To the defect in the order itself, the State Board does need more information than what is called for in the draft order. The State Water Board should request information from in-Delta water users claiming riparian and pre-14 water rights that supports each of the claimed rights, as well as identify the quantity of water that's being diverted under each of the rights that's claimed. The request for information should be made pursuant to the State Water Board's existing investigatory powers under Water Code Section 183, 1051, 5105, among other sections. The recommendation that the State Board use its existing authority is based on, in part, on a potential reduction in the level of controversy. I'm sure if you make the request, there is controversy, but my sense is there's larger controversy if the board were to be using its emergency regulation powers. The use of existing authorities also allows for the State Board to exercise strong response if the information is inadequate that's provided in response to the request. Specifically, the State Board has the authority under the Water Code to issue deposition notices, subpoenas that would request information to be produced. And I cite to Water Code Section 1080 and 1100. And the failure to comply with the subpoenas or the depositions may lead to contempt or sanctions. I cite Code of Civil Procedure 2025.440 and Water Code Section 1097. With that, I will conclude with a specific recommendation.
Thanks.
What the Water Authority would recommend is that the State Water Board, by October 1st, issue letters informing water users in the South and Central Delta of the State Board's investigation of claimed water rights, and that when you issue that letter, you attach a form similar to the form that was submitted to you by the state water contractors in the comments submitted for this workshop, that the State Water Board provide 20 days for water users to respond, and that the State Board warn water users that the lack of adequate response may result in additional requests, specific audits, issuing subpoena or depositions, and ultimately sanctions or contempt. Would also recommend that by November 1st, the State Board staff be prepared to act on inadequate responses. That if there's widespread inadequate responses, the State Board staff should be prepared to issue by November 1st deposition notices and subpoenas requesting the information, requesting the production of the documents necessary. If the responses, the issues with responses are limited, I would recommend an alternative action, and that is that the State Board conduct the specific audits, work informally with water users, and seek through less aggressive means to get the information that's necessary to support the claimed water rights. And then only if those targeted audits are not producing the information, the staff should be prepared to issue the notices of deposition and subpoena. And then finally, I do think it would be important that the State Board ask staff to provide periodic reports to the board on its efforts. First, as I understand your schedule, you have a meeting notice for November 4th. I would recommend at that November 4th meeting that the staff update on responses to the letters that were sent out on October 1st. I understand you also have a meeting scheduled for November 18th, and at that November 18th meeting for them to provide additional updates to you, whether they were pursuing depositions or subpoenas based upon widespread failure to respond, or whether they worked informally initially and then had to take action. And after those November board meetings, I think it would be important for more periodic updates as they seek information or as they process the information that they obtained. Thank you.
Thank you.
She has no problem with being
That's
last.
okay. Go ahead.
I'll be brief. And the reason we
Go
did
ahead.
it a panel was so as not to repeat information, but I concur with the comments made by Mr. Rubin and the response regarding information. In adopting the emergency regulations to protect senior water rights holders in July, the resolution noted that given the complexities with the relative priority of individual pre-1914 and riparian water rights, the emergency regulations would not include those users. And that was what appeared to me to be largely in response to a lot of comments you received that there wasn't sufficient information about those water rights for the board to act to curtail. And so this information will be helpful to the board to act and to put itself in a position in 2015 to act. And the impacts as described by Mr. Creel, which are conservative, and we were attempting to try to just to quantify the magnitude of the issue, because there's a lot of people saying it's a problem, but I haven't heard anybody, try to quantify it. So again, it's a draft, and we think it's conservative, and for the reasons that Mr. Creel stated, it has significant impacts on both projects, and it impacts most importantly, stored water and the ability to have that stored water available in case of a dry year next year. The request the State Board we request that you put yourself in a position in 2015 to act to enforce the water rights system in California consistent with water rights priorities. And we not only ask you that, but we expect that the board will act if next year is as dry and we're facing the same types of conditions. Even if we have normal precipitation, that is not going to equate in normal runoff, because we're following up on previously consecutive dry years. So there's going to be an impact to storage even in a normal situation if that were to occur. As to the issues raised in various letters, and some of the questions that were raised in the workshop notice, the state water contractors agree that those are important issues and that they need to be resolved. We think the proper process for those to be resolved is in the context of an enforcement action where we're having a hearing, and it's a formal hearing, and we have testimony, we have cross-examination, and it would result in an order that's enforceable against whatever water user, whatever the result may be. So those are kind of our closing comments, and if we're happy to answer any questions at this time.
Right. One of the questions that's been raised, now that you're coming later in the queue of folks, is the interplay between the legal questions and the information. Obviously, this goes on the premise that say the South Delta diverters aren't entitled to take that water. They've raised that either they are or that it's commingled. And so I'm not asking to resolve or talk about your position on it. It's just there's a chicken and egg argument to be made, and Ms. Valletta even made the point that perhaps you could do part of it in evidentiary and part of it certify it up to the court to try and make things go quickly, because even in, as you suggest, an enforcement context, we would have to make a judgment in order to even be in an enforcement context, and you'd have to resolve it in an enforcement. So either way, those questions come up. I see the issue of trying to deal with it in a true case or controversy, which is a classic way to resolve, sort of the normal way to resolve a legal question, but a declaratory relief or us resolving the legal ones isn't out of the complete norm. I mean, I think that's the obvious question that people listening throughout the course of the morning will ask.
Yeah, Madam Chair, I draw a distinction here, and to me, it's a very important distinction between the question of water rights and the question of water use and or availability. And my comments today do not go to the second issue. My comments today go to the first issue. That to ask how much water is available and who has access to that information requires an understanding of the water rights. And we don't have that in the Delta. As I stated previously, and apparently acknowledged by Mr. Nomalini earlier, the information that's been provided to you on statements of diversion and use is not the type of information that you need to do a thorough analysis from a water right perspective of the claimed water rights in the Delta. And to me, that is a foundational first step that should be the focus at this point. Personally, and from the perspective of the Water Authority, we don't know where that leads. But what we do know is that question has never been answered. That you look at the historical documents, and at least the historical documents that I have reviewed, have indicated consistently an assumption about in-Delta water rights. And therefore, that's why the Water Authority is focused on the information gathering. And where that takes us, don't know, except for one place, and that is some level of certainty that we don't need to assume. We will have a better understanding of the water rights, and we can use that, or excuse me, you can use that to better administer water right priorities, water right law during times of shortages.
Thanks. Okay, we'll keep going. Nobody's leaving. Good. Colleen Flannery, Assistant Manager, North Delta Water Agency. It says if necessary, so you don't have to, but would you like to? Good. Okay.
Good afternoon, Madam Chair and board members. We have submitted already some brief written, and I'm going to make some even briefer oral comments. Briefly, North Delta Water Agency is asking that North Delta water use not be counted in this order because this information was not asked for in the original request, and it would not be appropriate given the existing contractual constraints. And page 3 of the order currently states that the order applies to all pre-1914 and riparian rights holders in the Sacramento-San Joaquin Delta. So it does appear that North Delta Water Agency would be included in that. However, in the original July 23rd, 2014 letter from Mark Cowan and the U.S. Bureau of Reclamation, the request was to obtain information from South and Central Delta diverters and not North Delta Water Agency diverters. The contractual constraints come from the fact that the North Delta Water Agency 1981 contract is intended to act as sort of almost like an insurance policy. So it's layered on top of the existing water rights within the North Delta Water Agency boundaries. And the contract specifically is designed to require the state to furnish such water as may be required within the agency to the extent not otherwise available under the water rights of water users. So under this system, it would not be necessarily appropriate to ask for specific information from North Delta Water Agency users because it's not just their water rights that are supplying the water that they're using to irrigate their crops and take care of their families. And so finally, we're not asking necessarily for special treatment, but especially given the drought circumstances. But we are just pointing out that it would be more consistent with the contractual requirements and the original call of the question, as it were, to exclude North Delta Water Agency from this. Thank you.
Helpful. Yeah, we haven't limited ourselves at all to the question that was asked, but your point's a valid one. I actually have a question for staff unrelated to what you just said, which is, sorry, thank you. Thank you. I mean, one of the questions that we've talked about in this is our ability to administer the water rights system next year. So as you look at the information that you have across the board from pre-14 appropriators and riparians, do you feel that you have very good data everywhere else feeding into the Delta that's substantially better than what we have for the Delta? Or if you were going to administer water rights, should we be asking this question in whatever way, forum or however framed, all the way up, say, the San Joaquin, of specific landowners where we don't feel that we, or water rights holders where we don't feel we have adequate? That's sort of one of the questions that's been called by some of the commenters, which is why focus just on the Delta?
Well, first off, to answer the first question on the data that we have available from the Delta compared to other areas, I believe that there's a problem in all the data throughout on the reporting side of data under the statements. It's not only limited to the Delta. And one of the issues is the fact that they're triennially reported, so we don't
Right.
get a
And we only have one
annual.
set so far.
Yeah. So the quality of the data, I would think, would be suspect from other areas as well as from the Delta. The reason that the order is limited to the Delta is because the issue was use of stored water. And the fact that we included the North Delta was we wanted to get that use data in order to make a finding on Delta total use of stored water.
Has anyone actually looked at one of the theories that was posited earlier, that the streams may be recharging over, heavily pumped groundwater basins? Has anyone looked into that you know of?
We look at the flows that are available to the system. I believe we're talking about the above on the Pitt River.
Right, or
for the-
SAC, or, yeah.
Yeah, and then the SAC. So our gauging data that we look at would include those flows. The full natural flow calculations that we are utilizing may be above some of those points in our analyses.
So the answer is yes?
The answer is, it depends on which area of the accretion you're talking about. So if you're talking about the lower valley floor, then that accretion deduction would reduce the water supply downstream. If it's an accretion, it would increase the water supply that we're using. So if, in this year, if it was a groundwater area that is being recharged, then there would be less natural flow to some of the prior right holders downstream.
Did you want to add something? or
I
you
was just clarifying for the non-technical people myself that basically what John was getting at is that the gauging data that we use would capture some of that along the stream system. And I was just making sure that my understanding of that was correct, but that there may be a portion of the system that's not captured because the gauging data doesn't have an interim spot.
Well, I guess what I'm really asking is, did you see anomalies this year that you haven't seen in the past that might contribute to that theory that was put forward?
We definitely see changes in flows in different sections of the stream, whether it's caused by natural depletions or diversions, we can't tell, because some of the sections of the stream are, some of them are dry, and then some of them have very little flows, depending on the area you're looking at.
All right, we have a number more comments, but in the interest of being kind, take a 10-minute break. Bio break. Will. Janine? Wow, chocolate milk. All right, we'll reconvene. No, I just lost Fran. All right. I think we'll resume. I'm sure Fran will be back in a moment. Thank you. We have a few more speakers. Robert Melhalf from the Nagley-Burke Irrigation District.
Good afternoon.
Hi.
Again, I'm Robert Malhoff. I'm the Secretary and General Counsel for the Nagley-Burke Irrigation District. We are located within the Delta, just north of Tracy,
Thank you.
downstream from the Vernalis gauge. I wasn't going to speak initially. I just had a couple of comments that had to do with the practicalities of the information that you seek, and wanted to let you know what a request for information within 5 or even 10 or 15 days would entail. We measure our diversions by the kilowatt hours used in the pumps that are used to divert the water. We get those from PG&E statements at the end of the month. So if you ask us for specific information that is up to date to within 5 days, we simply wouldn't have it.
Right, we would have to ask for specific time frames that make sense, wouldn't we?
Yeah.
Yeah,
And
right.
so I just please take that into consideration. I mean, we're happy to provide the information that you ask for. It's just that we have to have it available from PG&E before we can do the calculations and then supply you with that information. Secondly, we did not initially suggest that legal issues should be decided first, but I really do want to endorse Ms. Spoletta's point. It seems to me that this process of trying to determine whose rights are senior and whose rights are junior and who's entitled to what water would be expedited if you decided the issues that the Delta folks have brought up, and that is we can draw from the Delta. Okay, if that is a yes in a court of law, then all of this stuff becomes irrelevant, doesn't it? in large measure. If we can draw mixed water that has an increased salinity in times of drought from the Delta, then why do we need all of the reporting and all of the other issues? So, and that's not the only issue that could be decided in advance, which I think would expedite the fact-finding that you want to do, okay? Lastly, I really do think that if you look at the chart that was just put up about the use of the water from the San Joaquin River, as I understood that chart, I don't understand how, if all of the surface flow is in the San Joaquin River flowing past Vernalis, how the possible use of that surface water could exceed what's flowing at Vernalis at that time. And yet, that's what that chart shows. The use line goes way above whatever happens to be flowing in the river at that particular point, at any particular point in time on that graph. I just don't understand it. I understand that they said that the use was determined by crop use, probably from aerial photographs showing the extent of the areas that are being irrigated or farmed, and some estimate of what the use of those water use per acre per year or per acre per month or per week. There's some estimate of use that was applied to that to come up with that nice little red line that shows that it was above what was flowing at Vernalis. Well, in looking at it, I could see that, you know, if it isn't in the river, we can't be illegally diverting it. So it couldn't be above the river.
Well, you mean the chart that the exporters showed?
Yeah,
Yeah, I think they were trying to show that you were diverting project water.
but it's.
That's
but
what they were trying to say.
How's the water arrive to us except through the Vernalis gauge in the river?
Right, so but that's the legal question that people differ on.
Yeah, but I mean, factually, how do you get more water than what's coming in the river?
Oh, I see
that-
what you're saying.
You know, you could argue alleged diversion between what's flowing on the Vernalis line and between what's flowing on the unimpaired flow line. I don't know how you get above the Vernalis line. That's the river that's all the water that's flowing in the conveyance system that's coming down the San Joaquin, that's surface flow. But, you know, I suppose if
No, I mean, I don't think that's what they're saying. I think it could be, well, I'll let them speak for themselves. Where are they? Are they still here?
In the back, there's John.
Do you want to just, I don't want to put words in your mouth.
Yeah, I'm a lawyer, not a technical expert.
John's there.
Meant to answer that caveat, and John, I might.
Yeah, you got to go to the microphone, sorry.
The blue line is the valley inflow. That's not including storage. That's what would come into the delta from the San Joaquin River. And the Vernalis flow is the gauge flow. And the reason that sometimes the black line is above the blue line is either some stored water from upstream. It could be return flows from upstream uses. And the blue line, like Mr. Creel explained, is conservative because it doesn't take into account any upstream use. It just assumes all that water is available.
Right, and so the red line, what?
The red line is based on DWR's modeling. It's the consumptive use in the delta, again, which is more conservative than what the water right is, because that's the actual amount of water diverted, and that's the consumptive use, and based on the acreage in the South Delta, which is roughly a third of the Delta acreage, that's the assumption that's made for the red line.
Yes, so just to add, I think what the exporter's argument is that then the difference between the black line and the blue line and the red line is stored project water that was diverted. That was the source of the water, which is above and beyond. So if they were just entitled to the flow of the San Joaquin River, they've exceeded the natural flow and the impaired flow of the San Joaquin River, so the water had to come from the project stored water.
Right,
I think that's the point.
I think what Mr. Melhaf is saying,
It's flowing in the Vernalis line at that particular.
well, the question is, wait, don't go away, Mr. Lehi, because I want to make sure other people understand what point it is, or John or somebody can come, is that would be, he's saying if the line says the Vernalis flow would include project and natural flow, at least from that part of the project, but there's also the Sacramento part of the project.
Right,
So were
correct.
you
So it would
refer-
have to be, the source would have to be the Sacramento side of the system.
Right.
Correct.
I think that's the point they're trying
And these are calculated numbers. These aren't actual numbers. So I think that's one of the points they're making.
Okay.
That you're getting more water in that system.
So far, these charts are sort of convincing me that evidentiary hearings are a good idea. I just want
Yeah.
everyone to know.
At any rate, those are my comments. If you have any
Okay.
questions, I'd be happy. Oh, just on the riparian side for just a moment, I'm sorry. Just to let you know, our district was originally part of Rancho El Pescadero. Rancho El Pescadero was a Mexican land grant going back to 1843. In our reports, we've always indicated that we've been diverting waters since 1912, but that's not original use. The 1912 figure has to do with when our particular district posted and recorded a notice of appropriation under the pre-1914 Act, and when most of the large canals and delivery systems that are in our district were built in the 1911, 1912 period of time. So I don't know how we would respond to your flows, or to your questions about what the date is, if that is, you know.
Well, the problem is that's what
pertinent.
everybody needs to respond to prove up their water right. I mean, we go through water rights hearing all the time in a case or controversy where folks have to go back to title and historical records. That's pretty common when you need to figure it out.
Yeah,
And so here the discussion has been whether we need to figure it out. On some parts, some people say we do, some people say we don't necessarily, and that's what we're trying to sort out. But it's not unusual to have to try and figure that out.
Yeah, the only thing is that if you're a riparian, I don't understand why
Riparian would be different than the pre-14.
Yeah.
It has its own twist.
Yeah, and the quantification of what the anticipated future use is really isn't on us. It's on whatever our farmers plant in that particular upcoming season. Thank you.
Oh, fair point. Rosine Reynolds, South Delta landowner. Hello. Hi. Good to see you.
Thank you all. Thank you for listening through this. I only have a couple of comments. One of them has to do with the idea that today we were not to present evidence, but we had two charts. We had one on EC, and then we had this other really interesting